All right, good morning, everybody. Hope your week is going well. So today we're picking up on the last few slides in chapter 4, and we're just talking about the examples of plural executives positions in Texas, right? So the 1876 Constitution reduced the appointment powers of the governor and took some of the offices that they appointed away from the governor and turned them into positions that are elected statewide, which of course reduces the ability of the governor to have any kind of you relationship based upon that appointment. So these folks are in a real sense politically independent, and that reduces the power of the governor. So it was a very important organizational change that we put into place in that 1876 Constitution. And so we talked about the lieutenant governor and how they're one of the plural executives. And now we're going to today pick up with comptroller of public accounts, which is very quietly one of the more important um, positions that we don't pay much attention to, but we really should. And the reason for this is that this is the office that is responsible for bringing in all of the state's taxes and fees and income, essentially, right? That's coming into the state. They're also the organization that is looking and projecting the state's economy out for 2 years. Remember, we've got this biennial legislature that has to budget 2 years into the future so that we can have the money we need to run the state government. And if you also remember, there's and I'm sorry for the loud background noise right now. It's just outside the office here, but they right, that budget is out there for 2 years, and we have to, because of our constitutional balanced budget amendment, ensure that we only spend what we bring in. The comptroller is the office and the person that's responsible for making the budget estimate, and that budget estimate is what serves as the maximum budget number for the state as they're working through developing their budget. So when the comptroller issues that estimate, whatever that number might be, that serves as the top level goal for the budget, right? It's not um, it's not the case that we can't exceed that. If there are funds that have been set aside that are outside of the budget but belong to the state, that those can be spent over the top of the budget estimate. But really, this is the forecast, right? The economic forecast for the state of Texas going forward 2 years. And then if those incomes start to drop off during that 2 years, right, the comptroller can come back and reissue the number and say, look, the economy is not doing as well as we projected. The income is not being realized as we expected it to. Texas as a whole needs to tighten their budgetary belts. And so that's when you'll see the legislative budget board start looking at things. You'll see budget execution authority be brought into effect, and the lieutenant governor and the speaker of the House will start to make adjustments to the budget that was passed because the estimates aren't accurate as they had hoped. Right, the economy changed, so there's a lot of major work of the state government that is dependent upon the comptroller and their agency doing the proper economic forecast, understanding how the monies are going to be generated in Texas, what's going to come out of right public lands income and things like that, as well as what comes in from the taxes and the fees. And so all of that has to get meshed together to make a good estimate. So this person needs to be someone that can at least lead a group that's going to be doing that kind of work and understand what that work is. They don't necessarily have to be an economist or anything like that, but they need to be able to understand the impact of their decisions and their estimates. Um, like most of these positions, this position, comptroller, is elected statewide. It's a 4-year term. We don't usually have term limits in Texas. There's no term limit on this office as well. So this is a place that you can get into office, make a big difference in what's going on, and quite often is perceived as one of those positions that is grooming you or helping it get you the experience you need so that you can move up in the political environment in Texas. So, in that sense, it's a pretty important element. And what it does, right, as far as uh, that plural executive experience, is it takes this major element of setting the budget and managing the budget perspectives out of the hands of the governor and puts it into this separately elected position. Okay, so let's move forward and talk about the land commissioners. So Texas has a good bit of public land, right, owned by the state that is also income generating, right? We have lands that, right, are agriculturally rich and generate income. We have lands that are mineral rich and generate income, specifically petroleum and gas, right? And so those lands that are income producing and belong to the state need to be managed. And so the land commissioner is a position that, again, statewide elected, so not answering to the governor, right? Working on their own electability and their own constituency, manages the state's land with right a couple goals in mind. One, obviously, would like this land to be as productive or income producing as possible. That money goes into several funds at the state level, right? The general fund, but also the permanent education fund. And so it's providing income for programs. It's something the comptroller is going to be watching closely, right, to see what incomes are coming in. Additionally, we know how important oil and gas production is to the economy of Texas. So it's not an insignificant part of the overall impact that state lands or public lands are providing, pumping oil, pumping gas, putting that into the market. And so someone needs to be managing when we're pumping that and when we're not, right? If the price of oil or gas drops too low, then it's really not worth the effort, right? To pump that gas or that oil and to refine that and put it into the economy. So generally, if I remember right, in Texas, the way we are oil producing lands is if a barrel of oil is not pulling in at least $50, we're probably not going to be actively using or generating that product and putting it on the market. And so someone's got to be looking at that and managing that. On the other side of it, right, both agricultural and oil producing lands have the I don't want to say opportunity, the possibility of being fairly environmentally destructive. And so we need someone at the state level that's overseeing those public land use and ensuring that it's being used in the most proper way, right? And that it's we have appropriate environmental policies in place to make sure that our land is not only productive but also protected. And so this person who gets elected as land commissioner has a pretty wide or broad area of concern that they're going to be working on, and one that comes with a lot of responsibility. So we should be paying attention to the folks that are running for this office. Again, In most other states, this would be a position that is appointed and answers to the governor, an office and an agency that answers unto the governor. And here again, the plural executive uh, excerpts that and puts it under its own standing, and puts the onus on the public to select good land commissioners that are going to look after Texans' property, right? Public property. So good position, right? Doing good work. It's something that Texas needs, but again, it is remarkable that a position like this is standing on its own electoral results, right, and not something that is tied to the governor's office. Akin to the land commissioner is agricultural commissioner, again, a statewide elected office, 4 years, no term limits. This is more of a regulatory position and a promotional position for private agricultural interest in Texas, whereas the land commissioner is looking after public lands that belong to Texas. The ag commissioner's job is one, to promote Texas agricultural markets to the markets across the U.S. and other countries, and to try to ensure that our agricultural private agricultural interests are competitive and being sold and are useful. So of course we're looking here at things like cotton and cattle and believe it or not, rice, very big market in Texas. Grapefruit, right, citrus products out of the Rio Grande area. So we've got a lot of unique and useful agricultural products here in Texas. We're fairly agricultural state. So there's a lot of market availability here to be promoted by the ag commissioner. And so their job is to be essentially the marketer / cheerleader for Texas agricultural products. The regulatory element of their job is to make sure that the laws of Texas that regulate how we use land and how we manage land, even private land, is followed, right? And so in that sense, they're looking at especially the big agribusinesses in Texas to ensure that they're being regulated in a way that the land is being protected, the land stays useful, that our agricultural products are sustainable. And so in that sense, they've been around for a while. The idea is to prevent things like another Dust Bowl from happening through bad agricultural practices. And so this office is looking at that. If I also recall, someone may want to look this up and fact check me on this. I believe the Texas Weights and Measures is under the Ag Commissioners, which is the group that makes sure that all of there's a standardization of weights and measures, which you're like, well, how does that matter? And it's like, well, making sure that when you that scales are accurate, so that when you purchase something based on weight, that the scales are working correctly. Also, the gas pumps, right, are something that's comes under weights and measures, and we have to make sure that when the gas pump says you've actually have a gallon of gas into your car out of the pump, that it was actually a gallon of gas, right? So that you're getting what you pay for. And so I believe, if I recall right, that's under the Ag Commissioner as well. So in that sense, what they're doing and how well they're managing things is going to impact you probably on a fairly daily basis, because they'll have folks whose job is to go around and test and ensure that scales of whatever type are accurate and working the way they're supposed to. Again, another position that in most other states is an agency or a board that answers directly to the governor, is appointed to the governor. Here, thank you, Bree. It's always good to know that I've got a little bit of memory still working. So it's another one of those things where we see the plural executive working the way the libertarians and the populists in 1876 intended for it to work. Um, so we've got a lot of different parts of our government that normally would answer to the governor that are under their own electoral power and their own position and answer directly to the constituents, which is um, a big boon for democracy in Texas and for understanding that we do have a role to play in choosing our government and who's going to lead us in these different areas. So, we just saw a lot of these positions on the ballot in the last couple of weeks and through yesterday, right, where we were working through picking these folks out within the primaries, so within the parties. Those folks that were successful in the primaries, right, and right, the ag commissioner, land commissioner, attorney general, all those were there, right. You're going to see them again in the general election in November when we have right the members of the Republican Party that were selected in the primary and the members of the Democratic Party that were selected in the primaries, and whatever libertarians that are out there, maybe Green members that come in. Their parties are smaller, so they don't use primaries, but there'll be candidates from those parties that make it onto the general election ballot as well. We'll see all of those on the general election ballot in November of this year. So we're moving through this process right now. We're making our voices heard on all of these different plural executive positions. And I believe that's the end of this chapter on the governor's office, and the plural executive. Are there any questions before we move to a new chapter? Okay, give me just a second here. I'm going to swap out our material. Okay, so let's talk about the court system in Texas. Really interesting design here in Texas, the way we do things and what it's for. So we're going to spend a little bit of time bringing some history in to give you a little background to understand why we do things the way we do. First, we need to understand what the purpose of all this is, where the law comes from, and then from that we can kind of follow up on the development of the courts. So historically speaking, we're looking at a very long legal history in the United States and Texas, and for the most part, they move along in tandem with each other. There's a little bit of uniqueness coming in from our history with Mexico and Spain, but most of it is actually tied to British common law, right, which is translated over to the U.S. and is kind of permeated through all the states except for Louisiana. So let's look at common law first, which is kind of as far back as we want to go historically. Common law is law that is developed historically, right? It is kind of the experience-based development of laws as we encounter new and different court cases all of the time. So what we have in that sense mostly comes out of the British common law system, British history. So if you go back into 14, 15, 1600s of British history, what you see is a monarchy, obviously, that is issuing law for the country as a whole. They are appointing sheriffs in that history to enforce the law, and then they come up with judges whose job is to go out and actually practice law among the people, make decisions. And so what would typically happen, right, if not to get too deep into it is sheriff would uh, come upon a situation, however that would happen, of someone being accused of the law, think there's enough evidence that that's the case, apprehend someone, maybe put them in jail. And those folks would then be waiting for a judge to come around to hear their case and make a decision and apply a guilty or innocent verdict, and then if there's a guilty one, to apply a penalty. And so these judges' job was to essentially ride from hamlet to hamlet, town to town, and be there, hold court cases while, until the jails are empty, and then move on to the next place and do it again in a sense. So what happened here historically that's really relevant to us is what these judges started to do. And they were motivated by applying the law fairly and trying to ensure that justice was done. And they needed a way to ensure that they were being consistent in their application of the King's law. And so they would record, they would write out the results of their cases as they were riding their circuit, their path around the towns and such. And so they would come into the town, the sheriff would bring forth somebody that was maybe accused of stealing, and the judges knew the King's law. They applied it to the situation, they looked at the evidence, they made a decision, and if the decision was guilty, then they applied a penalty. And there was, even like today, there was a range of penalties available. And so what they would do is record this whole process for each case, and and what they thought the law was that was being broken, and what they thought the appropriate range of penalties was, and then what they actually assigned as a penalty if they found someone guilty. If they found them innocent, then they would be recording why they were innocent and why the law didn't apply in this particular case. And essentially, they're building up a case book or a case history of decisions. And then they would organize that, but they would go to the next town and they'd say, oh, I've got another theft case, I just decided a theft case in the previous, and it was a lot like this. The facts were very similar. The law that was being applied for this, as I thought as a judge it should be, is this law. And therefore, as I will use all of that history, that precedent, to help guide me to make a fair, decision as I move forward, that, it'll be just, that I'll be handing out the same general penalties for the same general violations. And so they will record all this, and then get together and share that, annually or every other year with each other, We can meet back in London or whatever and share their decisions. And that history of developing these decisions based on facts and legal theories and applying consistent and constant penalties is what we call the case precedent or case history. And we use that today still. If you go to law school, you're going to spend 3 years learning the precedent of whatever your, some basic level stuff, and then whatever you focus in, you're going to be studying precedent. You're going to be studying the development of particular law and how it came about and how it evolved and all of the different things that went on. And you're going to learn to write case histories, and you'll be asked to present those in class, You'll have to stand up and say, okay, here's what happened, and here's what law I think applies, and here's the precedent that leads us here, and here's what's unique and makes us want to go maybe a little different, and here's the decision. And you'll learn how to do all that and how to make those arguments in law school. So this common law, this historical precedent approach to building new cases on top of older decided decisions is fundamental to how we approach the application of law to everybody, right? To all of the cases in front of us. And so if you don't have a strong historical grounding, um, then you're not going to really understand how the law is moving forward and how it's slowly changing and how it should be applied. And so we do this in Texas, right? We use common law, we use precedent, we use history all the time to make sure that we're treating like cases the same way and that we're providing common penalties if necessary that based upon the histories look the same, well, then we punish the same. If there's something extraordinary, then that brings in either maybe some exonerating circumstances where we punish them less, or some extenuating circumstances where we punish them more, right? So, but what it tries to do is it tries to be fair and just and take most of the idiosyncratic decision making away from the individual, right? And make it so that as a judge, if I were doing this, I would be doing it from a grounded historical precedent and not just, I'm feeling really mean today, so you're going to get the big end of the stick, right? We don't want that. We want the law to be, right, treating everybody the same. And our common law experience, right, brings that forward. Right? You'll see all the time, if you go to courtrooms and court buildings and stuff, you'll see Lady Justice portrayed as wearing a blindfold and holding a set of scales, right? The blindfold is to apply the law the same to everybody. The scale is to make sure that we're weighing out the facts and the punishment and that they match, right? That's the symbolism there. And that's underlies all of this common law approach um, to making decisions. Now that's a process, right? That's a history and it's a process and a perspective of how we do things, and therefore it provides a strong underpinning on how we want to develop law over time. The other thing, though, we have a couple other places where law comes from, right? Instead of just this historical precedent, and constitutions are right at the very base level of all this. When we're setting up that government, remember the Constitution is that foundational basis of law. It tells us who plays the game, what the rules of the game are, laws, right? How they get to play the game, how they can make new laws. So that Constitution is our foundational law that all other laws rest upon. Right. So we bring the process of common law in, that history, that perspective. We build a constitution that says, okay, this is what underpins everything. This is our fundamental law. And then as the system moves forward, it begins to make law, right, based on that constitution, based on that history. The Constitution, of course, creates the political players of the game. And in the United States and in Texas, the same, it creates, right, the same players. We have a legislature, right, with the House and the Senate. We have a court system, right, where we have Texas Supreme Court and the Court of Appeals and district courts and county courts, right? We'll look at all of those as we move through there. But all of those courts are created either initially in the Constitution or later through either constitutional amendments or through statutory law. Now, statutory law is law that is created by statute, and it is created by the legislature. So the Constitution creates the legislature, provides it the authority to make more law as long as it's constitutional in its nature. So when the legislature takes and passes a bill and makes it into law and the governor signs it and there it is, that's statutory law. It's created by statute that allows that organization to build it. It has to mesh with the base level, foundational level of constitutional law. And if it does, then we deem it constitutional and it moves forward and has impact on us. So, right, it sits on that constitutional base. If we move out of the state legislature and look to city governments, right, which are created by the state government, they pass ordinances, right? And so you've got your city council, right, which is a mayor and some city council folk. They serve as the city's legislature in a sense, and they pass ordinances which have the effect of law in the cities, right? And again, so based upon the Constitution, creating the state powers, right? The legislature and stuff can create other governmental entities such as counties and cities, and then pass process down to them, and then they too can make law. So common laws are history, constitutions are our legal foundation, statutory law is that law made by the deliberative bodies that are constitutionally created to do that. We have one other set of laws that we have to recognize as well, and that's administrative law. So all of the boards and commissions and agencies of the state, right, are challenged or charged with implementing statutory law, right? The legislature says, do something. This is going to happen in the state of Texas. This agency is responsible for making that happen. And so the agency has to take that statutory law and turn it into practice, right? Turn it into a procedure, a set of steps that the end result will be to enforce that statutory law to make it happen. The procedures and the rules and the practices that an agency builds and puts into place, we refer to those as administrative law. And the idea is that the government, the state agencies will, once they create these procedures and they go through public hearings and they go through public announcements and those rules are right solidified, then that's going to be the governmental process for applying whatever that statutory law was. And we refer to that process now as an administrative law, right? It's a law that is put into the books, right? Is reported to the government, is categorized and put into the right places, and then the agencies will follow that, and the regulated interest of that agency will also have to follow that. So if it puts into place a set of training perspectives or licensing perspectives, then how you get that license, what education you have to take, what the timeline is for that, all that's very practical design. But once it's all solidified and put into place, it's referred to as an administrative law, as the effective law. And all of the folks that are regulated by that agency have to follow that in order to get the result that they're looking for. The agency is bound to follow that. If they don't, there are almost always provisions in place that allow citizens to take that agency to an administrative law judge who's experienced and practiced in that particular in administrative law, and you can challenge that agency and that judge will hear your case and make a decision. And so it's very much just like if you were accused or breaking some kind of criminal law or civil law, you'd go before a judge. If the regulatory agencies have the same impact, then you'll go before a judge there if you want. So these are the places that we see law come from, out of history and out of precedent. Foundational law out of Constitution, statutory laws out of legislatures or legislature-like bodies, and then bureaucratically created law, what we refer to as administrative law. Hope that all makes some sense. So those are the four origins. Next, we'll talk about types of law. You already probably know this, that you'll hear about, differences between civil law and criminal law. A couple big elements here to keep in mind. Criminal law is where an individual is accused of breaking a law that the state's put into place, and that would warrant punishment of that individual. Um, and in this sense, right, it's um, you are being charged right by the state. You have done something that has violated the laws of the state or the county or the city. All of those are wrapped up in as the state in a sense, right? And so, right, we have statutory law that's out there that says you can't murder, you can't rob, you can't steal, you can't beat people up. All right, these are all criminal action in nature, in criminal actions of their nature, and they're the point behind them is to try to provide some sense of public safety and deterrence within society. And you will see these cases, right, where it's the administrative body, whether it's the city, the county, or the state, bringing a case against an individual, right? And the punishment that comes out of that could be anything from fines to right all the way up to the loss of your life, incarceration, right? And we have in place a expectation that the state has to make a case um, that removes doubt from the guilt or innocence of that person, right? The threshold is beyond a reasonable doubt. So that a common person, if they were to look at this and experience this, would say, yeah, I have no doubts that right this person is guilty, should be punished. If they have doubts and those doubts are reasonable, right? Like, well, I see some potential here for something else to have made this happen, not this person. Then the case hasn't been proved and shouldn't have a guilty plea or a guilty result. And so, in that sense, right, we're looking at what the government can do as an enforcement against an individual. And in the criminal sense, right, if you're found guilty of that, you have the potential of incarceration. Civil law is not right something that is someone breaking the peace, someone causing injury to persons or the law or something like that. Civil law is more law that's developed around making decisions between disputes, right? So someone says, "Hey, you damaged my property when you put this fence in, or when you had these cattle, or whatever the case may be, and I want damages. I want you to make me whole." Right? And it's not charging that the person, right, was a criminal in the sense of harming them, but there was misunderstanding, there was accident, there was something there that brought a conflict together as far as between perspective, and the court is being asked to adjudicate that, right? And to look at the evidence and look at the preponderance of the evidence as a decision-making factor. Now, the preponderance of the evidence means more likely than not, right? So in a civil case, you're saying, yeah, it looks like this is really the situation. I can see maybe some other possibilities, but this seems most likely, right? It's certainly not as high a standard as beyond a reasonable doubt. And so, right, and the reason that scale can be lower is because civil cases are cases where you're not going to jail. No one's going to lose their freedom. No one's going to be put to death. It's going to probably be some result of requiring someone to pay a fine, to deliver a service, right? And most of the time, it's going to be low-level disputes between neighbors or contractual disputes in business, something like that, right? And so there's a distinction here. And I'll give you a case. Most of you probably don't remember this, but we used to have a very popular football player named O.J. Simpson, running back in the NFL, Hall of Famer, Pro Bowler, all that kind of stuff. Well after his NFL career was over, he was accused by the state of California of murdering his ex-wife. Um, at the same time as the state of California brought that criminal accusation against him, the parents of his ex-wife um, brought civil proceedings against him for wrongful death and loss of companionship with their daughter. These cases, right, the criminal case proceeds first, the civil case usually comes later. So the criminal case with the state of California is accusing you of this. And at the end of the day, they did not make a case that moved the jury beyond a reasonable doubt. And O.J. Simpson was not found guilty of murder. However, in the civil case, with a lower level, right, of the preponderance of evidence scale, he was found liable for the wrongful death of his ex-wife and was required to pay some enormous fine to the parents of her. So, in that sense, right, he didn't go to jail. Court didn't make their case. The state of California didn't make their case on murder. They could have brought a negligent homicide or something like that, which has lower uh, things that you need to prove, and they didn't. They went for murder. They didn't prove it, and he went free for that. But with the lower level of the civil case, he was found liable. Notice that the term there is not guilty, but liable, right? And so he was required to pay an immense sum of money to the parents. So the other thing to remember here is that criminal law and civil law are kind of two completely separate paths generally to getting justice. They have little different goals, although justice underlies both. Right, one's settling a dispute, one is determining the impact and the problems of disturbing the peace of the state. So, in that sense, you got to keep these two things separate in your mind. Some of you may be thinking, but I've heard before, been told before that you can only be charged for a crime once and only be tried once, right? And not be subject to what we call double jeopardy. But the distinction between civil and criminal is the double jeopardy applies in those two individually, right? So he can't be tried again for the murder of Nicole Brown Simpson, but he could still be tried outside in the civil process. There's not a double jeopardy there. So keep that in mind, right? When we're talking about anything going forward, we need to be first understand, is it criminal law or is it civil law that we're talking about? All right, let's see. Our next slide here is on types of jurisdiction. I think I can probably cover that in the next 5 minutes or so. Or no, I got a little longer than 5 minutes, don't I? Okay, so Morgan here is saying, so high stakes civil cases settle out of court since plaintiffs are more likely to see compensation. Yes, that's one of the elements of a civil case that you would see much more often is that. And you could see it in a criminal case, but we would call it in a criminal case a plea bargain, right? In the civil case, right, you're looking at those monetary payments, or you're looking at a charge for some kind of service to be done, right? You have a contract and someone says they've fulfilled the contract, and the other element of the contract, that person says, no, you didn't, right? What you delivered isn't up to appropriate quality. Quite often, you'll see that in a civil case, like someone has been hired, a company's been hired to come in and make and pour a swimming pool, and tens and tens of thousands of dollars have gone into building this pool, and then you get the final product, and the customer is not happy, right? They've spent 80 or 90 or $100,000 on a pool, and then it's not what they thought they had contracted for. It's not what they expected. They would, right, if they couldn't get, right, just through negotiation what they wanted, they'd bring a civil suit to either sue for fixing the pool the way that they think the contract specified and wasn't met, or getting some kind of lump sum payment that would allow them to fix the pool going forward on their own if they didn't want to. And so, yes, you could see out of court settlements, right, where the plaintiffs are come to some negotiated agreement on their own and then drop the case. The same kind of thing happens in civil criminal cases where you have plea bargaining, where the court encourages the prosecutor and the accused, right, to get together and to look at the evidence and right, try to avoid going to court if necessary. And so there are inducements given from prosecution to the plaintiff, right, to the accused, saying, hey, we will probably bring you to court with this charge, which carries this possible penalty to it. But if you'll plead guilty, we will lessen the charge to something a little lower that has a smaller penalty. And so if the evidence is such that the accused is like, yeah, I'm pretty much easily shown to be guilty here, they will negotiate that. They'll plea bargain there, and they'll plead guilty to a lesser crime and get a smaller penalty. That's a benefit, obviously, for the accused. It's somewhat of a benefit for the criminal justice system as well, because there are a lot more cases than the prosecutors can bring. And so a plea bargain case avoids the long and expensive process of moving through a court trial. And it does get this person that's accused of wrongdoing fessing up to that they did it, and then paying the penalty that is at least somewhat appropriate, but lessened because they short circuited the circumstances, right? So judges will encourage that because they don't have enough time to hear all the cases that they have anyway. It's not the best case of justice being delivered the way it should be, but it is one that is very practical and lets the system move forward and handle more issues. Does that make sense, Morgan? Okay. So types of jurisdictions. When we look at courts in Texas, courts anywhere, courts are assigned jurisdictions. In other words, they are assigned types of cases that they're supposed to hear, right? So you'll have cases that are original in their jurisdiction. Those are cases where you're going to have what we think of when we watch court cases on TV, where there's facts brought in and there's judges, determining fact, maybe a jury, maybe not, but we're trying to, through the legal system, figure out what really happened. That's the establishment of facts. And then giving what we established as a set of facts, applying the law appropriately, rendering a verdict. If it's a criminal case, then we're going to look at what did they do? What proof do we have that this person did that? If there's enough proof and the elements are all there, then we will find them guilty. If not, then we will find them innocent. If we find them guilty, then we will, have to apply some set of circumstances to render a penalty on top of that guilty verdict. If it were a civil case, of original jurisdiction, it would be, here are the facts that we've determined about what actually happened. Here's the contract or the law that's in play. And here's the accusation of a violation of that process and that principle. And then what needs to happen if we find that person liable. We don't usually use guilty in civil cases. We find them liable, then we'll render a verdict to try to make the aggrieved party whole, right? And so replace guilty and innocence with liable or not liable for the case. So any case that is being brought into a court where you're finding facts and rendering a verdict is going to be a court that has original jurisdiction because they're making the decisions. They're applying the law, they're coming to a conclusion. A second type of jurisdiction that exists out there is what we call appellate jurisdiction. And appellate jurisdiction is a review process where a second court reviews the processes and procedures that a lower court applied, and their job is to ensure that that lower court did the legal work properly. They're not making a decision. They're not finding facts in a case. They're not doing guilt or innocence or liability or non-liability. They're saying, right, there's someone or some party that has said, hey, this court didn't work the law the way they're supposed to. They didn't follow the law. They didn't apply the law. The judge was partial, not impartial. They're making some assertion that justice didn't happen the way it's supposed to happen. And they make that assertion to a court that has appellate jurisdiction. And an appeals court, right, will bring that up and review all of the circumstances, all of the decisions made, all of the application of law, and see if they agree with what was done or not, and then issue orders based on what they find. So an appellate court is right are set up or designed for review to try to make sure that our courts of original jurisdiction are doing things the right way. Those are the two main types of jurisdiction that you're going to need to think about and keep in mind. There are two other types here: exclusive and concurrent. Exclusive would apply to a court that says you can only exclusively do original work or you can only exclusively do appellate work, which implies, and as you'll see in Texas, we have a lot of courts that do both. So they're not exclusive, right? So a court can be both a court of appellate jurisdiction and original jurisdiction, unless it's applied this term of exclusive. And that limits them what kind of cases can come through that court. Concurrent jurisdiction is one that we're going to talk about a lot, especially here in Texas, because concurrent jurisdiction tells you that there are two courts, right, that either of them, right, could try the case. So if you had a criminal case, there are maybe two courts that prosecutor could take that criminal case to. So you have concurrent jurisdiction in different courts. Both of them have, right, legal authority to hear the case. This is not ideal, right? Ideally, that every court would have a very specific jurisdiction that could apply, and that there wouldn't be different courts or different levels of courts that have that same jurisdiction. But unfortunately, the history of court development in Texas and the designs of courts in Texas, this is a problem that we're going to see a lot of, right? We're going to see multiple courts that a prosecutor could look at or a plaintiff could look at and say, I want to take my case there instead of over here. They could take them, right? The person bringing the suit is choosing what jurisdiction, what court to hear their case in. That's not ideal, right? When you have two different types of courts that have the same jurisdiction, you are giving the person bringing the case, the complainant in this sense, whether it's the state as a prosecutor or the plaintiff as in a civil case, you're giving them the choice to pick their venue, which might be unfair to the person or the group that's being accused of wrong action. Because the person bringing the case is going to choose where they file the lawsuit. And so I'll point this out. We're going to move through all the different levels of Texas courts, and we'll show you where we have these concurrent jurisdictions. That's both confusing and problematic in the sense of just and appropriate action by courts. So these are the four types of jurisdictions. Most of the time, we're going to be paying attention to whether a court has original or appellant, and then sometimes we'll look at exclusive or concurrent. So you need to know what those are. Okay, so let's do it. Let's jump into the designs, the court systems of Texas. So this chart that you're seeing here lays out all of the different courts in Texas, types of courts in Texas. It moves from the smallest courts at the bottom up through right from city and municipal and precinct level courts to county level courts to state district courts to appeals courts and then to our final courts of appeals, right? So, and the black lines that you see on this slide are showing you where, if you were to appeal from an original court of jurisdiction to an appellate court, where you would take that appeal. So those black arrows are showing you the proper appeals process. So we're going to start at the bottom, and we're going to talk about justice courts, and we're going to talk about municipal courts here first. So justice courts. You see here on the second line of this little box here for justice courts, it tells you how many justice courts there are in Texas and how many judges there are. So you see 821 courts and 821 judges. So each of these justice courts has one judge. These justice courts are our lowest courts of local trial courts, right? So this is where you're gonna, you got a small problem and you need a judge to work it out. This is where it's going to happen. These courts have both criminal and civil jurisdictions, so they can hear both types of cases. You see here that this says a justice court can hear a civil action of not more than $10,000. So if plaintiff is bringing a case in and they're asserting that they've been harmed for, I don't know, $8,000, this would be an appropriate place to file that civil case, right? $10,000, no more than $10,000, which in the big scheme of things, right, it might be a lot of money to you, but in what the court systems are going, 10,000 is pretty small. We also do small claims courts where you really, very small amounts, right, where you need just some justice to deliver some kind of semblance of a decision. These courts also do civil misdemeanors, but notice there's a limitation on that. These criminal misdemeanors can be punishable by fine only. So justice court judges cannot send anybody to jail. So criminal mischief maybe, or something like that, where there's been intentional property damage. Someone's hurt somebody in that sense. Maybe I'm not sure. Probably a simple assault would fall in here, right, where you've pushed somebody or spit on somebody or something like that. And then these courts also do magistrate functions, and magistrate functions are where you need a judge just to sign documents, right? To make things official, where signing a marriage certificate, maybe doing a death certificate or something like that, right? Where there's no case or trial here, but you want someone that's impartial and is a judge to make something official. So these justice courts judges would engage in these magistrate functions. Now, if you know a little bit about Texas counties, you'll know that counties in Texas are broken into generally 4 precincts, right? Geographical areas within a county, those 4 precincts. 254 counties, I think, in the state of Texas. And most of them have 4 precincts, which is where you get that 821 courts, right? Now, not all of them, right? Some uh, counties that have so few people in them that's just one precinct or two precincts, and so you don't get 254 times four, right? Which would be more than 821, but we're pretty close to it, right? So these, in other words, these folks are right. 800 judges are elected to these positions, right? We elect all of our judges in Texas. Um, and so all of these elected positions are ones that if you live in the precinct or live in the district or live in the county, right, depending on which one we're looking at, you would have the ability as a voter to help pick these people. So this is kind of it's our precinct based within the county design of courts. And this is the first and original courts right at the local level. So when you go back into the history of Texas, right, these are the ones that you're going to see first being created to take care of the work, the court work down at the local level. Texas Constitution creates Texas Supreme Court and then says the legislature has the ability or authority to make other courts. And so these other courts, the ones that are lower than this, right, come out of that authority. And so these are our county-based courts of right at the precincts level. Their companion level court are municipal courts. And municipal is the proper term that we use to refer to cities, right? Cities and towns and such. So when the legislature charters a city, right, lets them come into existence, one of the things that lets that city do is have city courts or municipal courts. There are 900 plus cities in the state of Texas that have municipal courts. 1,400, some odd, maybe more, right? Judges that get maybe elected, maybe appointed, depending upon the city charter, to these positions, right? So this is the kind of one of the exceptions to we elect judges in Texas. They're municipal courts. They may be appointed by the city council or by the mayor or something like that. The jurisdiction of these courts are criminal jurisdiction, where you have criminal misdemeanors punishable by fine only, no confinement, which is the same as we saw in the companion court at the county level, right? They have exclusive, there's one of our terms, original, there's the second one of our jurisdictional terms, jurisdiction over municipal ordinance criminal cases. So cities, right, can make their own ordinances applying to criminal law that are different than what's coming out of the state and apply at the county and precinct level. So, right, it makes sense that if the city made that criminal law, that the municipal court would be the one to hear cases against it or by it, right, and apply the municipal or the city law to it. So this is something, right, exclusive and original to municipal courts. These courts have limited jurisdiction in cases involving dangerous dogs. I don't know why, but there it is, right? I would imagine that that's something to do that there's maybe a different way we treat dangerous dogs in city jurisdictions versus rural jurisdictions. And so that may be something there that gets them a limited jurisdiction there. And then they also do magistrate functions. Now, there is the potential here for concurrent jurisdiction to occur, right? There could be a situation where an occurrence has happened that would fit under the justice courts or under the municipal courts. Most of the time, if a case here fits under the municipal court, that's where it will be tried. So the general practice is, right, even though there might be concurrent jurisdiction, you could go either way. If it's within the jurisdiction of the municipality, it's going to be tried in the city courts. If it's outside the municipality and in the unincorporated areas, then you will use the justice courts, right? The justice of the peace courts. And this is just the kind of practical way of splitting those cases up. So the opportunity for concurrent jurisdiction, taking a case to either one is there, but the practice is a little more limited in that sense. You'll see here that both of these courts, if someone were to appeal, right, to assert improper action on the court or the judge, they would appeal from the justice courts or the municipal courts to a county level court, right? And so we've got three different types of county level courts. Now we have 254 counties, we have 494 courts. And we'll explain that, why that doesn't match up, right, as we move through these. So the oldest courts at these county levels are the county constitutional county courts. Notice there are 254 constitutional county courts, one for every county. And the title here gives you a clue, right? The state constitution, right, says that there will be in every county created by the state a constitutionally mandated county court. And so these are the ones that go back, right, the furthest in history in Texas. So these are your county judges, the ones that you're going to see referred to as a county judge. Their original jurisdiction in civil cases, any case where the amount will fall between $200 and $10,000. Right now, the concurrent jurisdiction issue ought to be popping into your head because we know justice courts, right, working in the precincts within the counties can do civil actions of not more than $10,000. So an $8,000 case could be filed in that justice court, or it could be filed in this constitutional county court. Probably not the municipal court, but maybe, right? So, so this means, right, whoever's bringing that civil action that feels whoever the aggrieved party is, gets to look at the judge that's going to be sitting over their case at the county level or at the precinct level and choose which one they want to be their judge. And that's not good. Remember, justice is supposed to be blind, right? You're not supposed to be able to choose who is going to decide your cases because that makes it maybe less than impartial. So let's say you're a prosecutor looking to bring a case and you play golf with a judge of the constitutional county court, but not the one in the justice court. Well, if you're friends with that judge, you probably want to bring your case there. That's not a good design to have in place, right? We need, if we're going to preserve this idea that justice is blind and applies to everybody the same, we shouldn't let people bringing cases shop for their judge. But the design here, the historical design here that we have in place does, right? And then by referring to historical design, I'm just talking about when these courts came into being, where their authority was from, and what they were needed for. And so in that sense, we saw expansion of jurisdictions that ended up with overlapping concurrent jurisdictions. Second constitutional county court jurisdiction is over probate. Probate is how we decide after parties pass away how to parse out their estate. This is rather complicated. Takes their special law here that's applied. So this is something that's going to be kind of focused at the constitutional county level. Now, if you look to the far right of this same box, you'll see that there are statutory probate courts. These were created much later. They are in places where there is a high population count. You're going to have a lot of probate courts issues. And so there was the need to have courts that did just that. And so we have In these high population areas, we have specialty courts that handle probate, but in most counties, right, um, the constitutional county court's going to be the place that handles this. If you have a probate court, your probate will go there. If you don't, it'll be handled by the constitutional county court. Um, Constitutional county courts have exclusive original jurisdiction over misdemeanors with fines greater than $500 or a jail sentence. Now, remember, the justice courts had a jurisdiction of criminal misdemeanors punishable by fine only. So again, there's an overlap here of the law that's can be tried in each place, and that's our concurrent jurisdiction that we don't like. Juvenile matters, right, where will be tried in constitutional county courts. And then the last little element here is county trial courts is the appeals de novo. Appeals de novo means appeals that are going to be tried anew. So what happens here is justice courts, as our lowest level court, right down at the bottom there, they, as a rule, are not required to keep records of the decisions they made during a court case. Historical, right, anomaly that's being addressed sometimes. So some are doing or some not. So if you appealed out of one of these justice courts and there was no written record of the judge's decisions and the law applied, you don't have anything for the appeals court to review. And so in that case, they will have to retry the case, and they will retry it at the constitutional county level. So an appeals de novo is an appeals where there is no record, right, that comes up to the higher level court, and they will try that. Now, if there's a record, right, then and municipal courts, because they come along later, almost always have records, right? The appeals process will be a normal one. They'll look at the record of the case and review all that and make their appeals decision. But it won't be, right, trying the case again. It'll just be reviewing the case appellate. But the appeals de novo, where there's no record, requires, right, that you work through it again. Okay, so that's our constitutional county courts at law. Our second level of county courts here are called county courts at law. And they are a statutory court. In other words, they were created by the legislature, right? That first category over there to the left is constitutional county courts, telling you that these courts were created in the Texas Constitution. These county courts at law are created by statutory law. So the legislature said, we need more county courts. 255, one for each county, doesn't work in every county, right? You couldn't do a single constitutional county court in Harris County or Tarrant County or Travis County, right? Bexar County, any of those, right? You're going to need more courts than that one constitutional one. So the legislature creates these county courts at law where they're needed. And they essentially say, hey, we're creating these courts, and they're going to have generally the same jurisdiction as a constitutional county court, right? Because that's what we need more of. But the Constitution only creates one per county. So we're going to create these that look pretty much the same, except they're newer and they're updated a little bit to handle, right, that caseload that's occurring at the county level. So they have all the civil, all the criminal, original and apparent jurisdictions that the constitutional county courts have. And then, right, in civil matters, they have an expanded economic range, right, where the constitutional county courts are limited to $10,000. County courts at laws can go up to $100,000. Some can go even more than that, right? So again, the legislature creates these and then builds the jurisdiction as needed. So they have by design concurrent jurisdiction over a lot of the same stuff. Does that make sense? So this is our more modern approach to ensuring that we have enough courts out there to handle the immense load of cases that come in at the county level, right? And you can see by their name, one is constitutional, one is at law. So they come, their jurisdiction is given to them through different foundational beginnings. Okay, so we're halfway through this slide. We will call this a day, and we'll come back and pick up with district courts tomorrow, or not tomorrow, Monday, right? So have a good weekend. Keep your readings going. Keep those, keep working on those quizzes. It is, if you haven't, it is time to start working on your paper, right? We're coming up on about the halfway mark of the semester. So you need to look at your current event paper, have chosen a topic, and start doing some of that research and reading that you're going to need to make that paper happen. Again, if you have any questions, office hours were this morning from 8:15 to 9:15 on Zoom, but you can always reach out via email or text to me, and we can set something else up. Either I can answer your email, or we can set up another Zoom or something like that. So if you need me, don't hesitate to reach out. All right, everybody, unless there are questions, have a good day.